Civil 20-0229, Cleveland versus Marco Crane. As you are familiar, each side has a maximum of 20 minutes for argument. You're not required to use it all, but you are welcome to do so. As for the appellant, you may reserve some portion of your time for rebuttal, although you are responsible for managing your time. Now, because we're handling the argument remotely, and we do appreciate you accommodating us on that, I will be keeping manual time and I will periodically alert you of your remaining time. Feel free to ask for an update at any time, and also feel free to keep your own stopwatch or clock going. We are recording this argument. We will ultimately post that recording to the court's YouTube channel. So for clarity of that record, please do identify yourself and your client when you begin speaking. And we hope, as always, that no connection failures occur, but should one of the judges lose a connection, we will just keep going and that judge will review this recording later. Now, if one of the attorneys loses a connection, we will of course suspend the argument until the connection's regained. As usual, keep in mind, we've read the briefing, we've studied the record, we discussed the case in conference this morning. And with that, appellant, you may proceed.
Thank you. May it please the court, my name is David Abney, representing the appellant. The central issue in the case, as far as I can see, is whether the crane operator, Benny Ellsworth, transformed into a special employee of the construction company. And if he did, then the construction company if he did, then Benny's own employer, the crane operator, has immunity. It cannot be vicariously liable, and that's the end of the discussion. We reviewed this pretty carefully at the Superior Court, and then again at this court. We went over the three-part control test, and then the restatement test as to whether somebody's been transformed into a special employee or not. And no matter how you slice it, it looks to us like the crane operator, who was there very briefly to do a very short series of tasks and then leave, did not become a special employee of the construction company. If you run down the various factors, I think that's a solid conclusion and a defensible conclusion. First of all, the control factor, which in both tests it comes out first, and I think importantly so. But the control has to be the control over the details of the work, and not simply giving somebody directions and communicating with them about where they're supposed to put the loads in the case of a crane operator.
Well, counsel, the crane operator can't. His job is to operate the crane under the direction of the people giving the directions. So if the lumber company doesn't, the employee of the lumber company, if he doesn't give the crane operator the directions, the crane doesn't move because the crane operator doesn't know what to do. So why in this specific instance, why doesn't that put the crane operator under the direct control or a special employee of the lumber company, or whatever the company is?
Well, the crane operator controls the details of how he is operating the crane. Someone is simply giving him directions as to where you put the load. That's not the same as how you operate the crane itself. It would be
counsel. Let me ask a question, because you've talked about the control over the details. This is the second time you raised that point. Is it your position that in order for Timber Peaks to have been in control, Timber Peaks would have had to have been in control of exactly how Ellsworth was moving the crane, literally telling him move this lever or however it is?
Yes, it would have to be that sort of control.
Is that ever done by anyone?
I doubt it would ever be done with a crane operator. If you know your business is the construction trade, you get the crane operator on the job site because the crane operator is a specialist. It knows how to operate a very big, complicated piece of machinery, especially these days, because many of the cranes are operated by a computer system, and you have to know how to how to operate the computer controls to make sure everything works properly. So yeah, you'd have to get down to the level of controlling the actual details of levers, switches, and that sort of thing to be really in control of it. And I gave two examples in the briefing. Suppose you have a cement mixer comes on the job site and puts the cement into a form where it's supposed to go, and accidentally swings the boom too wide and crushes one of the employees there. Is anybody really going to say that that cement mixer operator has become a special employee of the construction company? Or if a delivery van comes to drop off some shingles or whatever for the job site, and somebody says, well, back it up here, and as he's backing up to the spot where he's been directed to back up, he crushes one of the employees because he's negligent. Is anybody going to say that the delivery truck operator has become a special employee of the construction company? No. And this is not really any different than that. You have the crane operator there and somebody says, okay, we've got this load. We want you to move it from point A to point B. And it's up to the crane operator how to control the details of getting whatever it is from point A to point B.
But the involvement was a little bit more than that because, in fact, Timber Peaks was saying, not simply, I want you to move this lumber or this wood sheeting from one place to the other, but I'm telling you, move it now, move it in this fashion, move it, stop, move it when I tell you to. And I'm assuring you that I have taken off the straps, the two straps, and now you may proceed. So there's more involvement than simply, please come in and move the wood sheeting and let us know when you're done.
Not a whole of a lot more. I mean, he's the crane operator's in the cab and control area and taking some directions and instructions about what is going to happen with whatever he's supposed to move. And that's really all that he's doing. So he has to depend on directions, but that's the same as anybody coming on the job site to deliver any kind of material or move it around at the job site. You have to have some sort of directions or the system doesn't work.
So let's talk about a different example. Let's talk about a nurse, for example, that comes to work for a period of time under a different employer. Would that employer, in order to have this special relationship, would that employer have to give the nurse, give him specific instruction? For example, if the nurse is going to give a vaccination, uh, first would have to say, the special employer would first have to say, be sure to swipe the skin, swipe it again, swipe it 3 times, and now inject in this fashion, or take out this much out of the vial, and be in direct supervision of every movement that nurse makes uh, before the relationship is established? Or
Probably yes.
simply, go ahead. Yes?
Yes, yeah, I think so. But
Okay.
maybe yes, but maybe a better example might be a phlebotomist. We get a lot of these phlebotomist cases because phlebotomy, the sticking in to get the blood sample, is an art. It's very, very hard to hit that vein at exactly the right spot, and you really breathe a sigh of relief when an experienced phlebotomist is on the job doing the draw.
I know what you
That's
mean.
well, most adults have gone through this by now. Somebody hunting for the vein, but the point is you got a highly trained specialist and who maybe come on to a clinic to work there temporarily, and it just knows what to do and says, okay, I want you to take this particular patient and do the blood draw, and from there on the specialist is in charge of the details. And there's not much difference here between you're a crane operator. I want this load moved to this spot, and I don't. It doesn't matter to me the details of how you do it. I want it done. Move it from point A to point B, and that's really all that's going on here. He's on the job.
But Council, that doesn't quite seem accurate from the record. They wouldn't say we want the load moved from point A to point B. They were giving the crane operator specific directions about how to move it from point A to point B. I would have a lot more sympathy to your argument if it was simply moving from point A to point B. I don't care how it gets from point A to point B, but that's the crane operator's job. But when the crane operator is depending on specific directions on how to move it, in what manner to move it, that's when I have more difficulty with your argument.
Well, I submit that on the record, what it really is fairly simple what happened. I mean, there's going to be a little bit more in the way of direction than simply point A to point B, but not a whole lot. Is they're saying this is the load, it's ready, pick it up, move it, drop it. That's all that really happens. And that's not controlling the details of how he is actually managing to get the crane to do what the crane is supposed to do.
So the hand signals didn't matter.
They matter in the sense of direction and communication, but it doesn't matter in the sense of control over the details of what he is doing in that cab control system, the crane control area, to make sure that he gets the load from one point to another point. He's in charge of those sorts of details. Nobody else is. That's why they brought him on the job site. They can't handle a crane themselves because it is a specialized sort of thing. He's doing it. They're simply telling him where to pick it up, where to move it. There's not a whole lot more going on there. And it doesn't transform him. Go ahead.
Can we talk a little bit about the Terran factors? And so we have a situation here where there's the contract that says that Timber Peaks is going to exercise control over this employee, and they in fact, to some degree, exercise control, get involved in telling him what job to do, and not only in this case maybe for 2 hours you submit, but for subsequent jobs as well. So it was 3 different homes, as I recall from the record. So we have a situation where we have the contract and we have the parties apparently acting in conformity with that contract. Can you talk to us about that, about why in this particular case the evidence is not such that there was actual control being exercised by Timber Peaks, that they were acting in accordance with the contract, and that therefore reasonable people could not agree with the conclusion that you're advancing?
Well,
Council, you have
first-
about 9 minutes.
Well, thank you. For the special employee situation, the control that matters is control over the details of the work, not simply a general flagging of where you want to pick something up and where you want to drop it. This is a very odd thing because what Ellsworth was doing at the job site was doing his job of making sure that he picked it up and moved it where they directed him to move it. And then later on, he says, well, I was under their complete control after the lawsuit starts. But that doesn't really match up with the reality of how this kind of operation works and what he was actually doing. And then, of course, you get to the nature of the work. Ellsworth's job is using a crane to move things. That's what he does. Timber Peaks' job is to build homes. So you have a disconnection there between the nature of the work. What you're looking at here is proposing, it seems to me, the other side is proposing this rule that anybody who comes on the job site to do anything, no matter how briefly, as an expert in whatever field, is automatically going to become a special employee of the construction company. That seems like a very bad outcome, a very bad public policy outcome of what would happen here if the court decided to go down that path. And I submit to you what should be done is what's been done since the 1909 case. I think it was Standard Oil case. If you got somebody operating a crane and all they're doing is cooperating with simple directions about where to pick something up and move it, that isn't enough to transform that general employee into a special employee and make the employer immune from any sort of lawsuit, not vicariously liable. That just doesn't make sense. And I know these cases are old. It seems like, maybe there's 100-year cycle in the common law that we come back to the same thing that was decided a long time ago. And we are back to the same sort of thing. Simply giving directions to a crane operator is not enough to transform that crane operator into a special employee, and with good reason. As I said, it would be a heck of an extension, and it would apply to anybody who comes on that job site. Cement mixer drivers, delivery drivers, anybody who's there and temporarily takes a few directions from somebody at the job site, then they automatically become a special employee. I don't think that's how tort law is supposed to operate, and the public policy outcome is pretty dramatic.
And well, Council, just so I'm clear, the mechanism of the injury was because the log being moved remained tied at one end when the ties should have been removed. The crane operator didn't have any control over that, correct?
I don't think he did. I think well, here again, I'm not quite sure what the exact negligence of the crane operator is, whether he had a duty under the standards, whether under the standard of care he was supposed to double check to make sure that they'd actually tied the load correctly or not. And that matters for the future in case we go forward. I don't want to close any doors on the crane operator's liability or on his employer's vicarious liability. But yeah, it seemed to me that this happened fairly soon in this whole operation, that he's actually picking up what may be the first load. I can't really tell from the facts. And then it just all comes apart. It hits Gerald Cleveland and knocks him off, and down he goes, and he's terribly hurt. So yeah, this is very early in the process, and I'm not quite sure how a jury's going to assess the percentages of fault. But thank God that's a fact question for the jury to decide, and not for me, and not in this particular case.
Sure.
But I
Counsel,
think
you have about 5 minutes.
Well, in that case, unless there's any questions about the double dipping, and I don't think there is double dipping in this kind of case, then I will we'll stop talking.
All right, thank you. I'm going to pause that. You have just under 5 minutes for rebuttal. I'm going to reset the clock. Judge Cruz is going to try to rejoin us. So I'm going to give it just a minute to see if she's able to do so.
Okay, I'm gonna mute then.
Great. All right, Mr. Lishko, we'll give it maybe one more minute, and if we don't see Judge Cruz, we'll go ahead and get started, okay?
Sounds good, Your Honor.
Well, it seems like she's not having any luck. Hopefully she'll join us. But again, the recording is still going, and so Judge Cruz will have the opportunity to review that recording once we conclude. So with that, if you are ready, Mr. Lishko, we'll go ahead and get started.
Will do, Your Honor. Your Honor, briefly, I wanted to restart just by reciting the undisputed facts that were before the Superior Court. Now, Marco Crane is an equipment lessor, and pursuant to a short-term rental agreement, it leased a crane and a crane operator to Timber Peaks Construction. And the language of that contract is very important. It said that the crane and the crane operator were to be under the exclusive direction, supervision, and control of the customer, that is, Timber Peaks. What was stated in the contract is what happened on the ground at the actual construction site. The morning of, the crane operator showed up, and he was met by the Timber Peaks foreman. The Timber Peaks foreman said to him, "I'm the boss. You look at me and no one else unless I tell you otherwise." And the evidence was that at every step, the crane operator followed the directions of Timber Peaks employees and no one else. Timber Peaks decided when the materials were to be moved, what materials were to be moved, and where they were to be moved to. No one from Marco Crane, with the exception of the crane operator, was present that day to give directions. And it's undisputed that the appellant was actually injured when he gave the cable up signal, which the crane operator followed. So to be clear, Your Honors, a Timber Peaks employee told the crane operator what to do. The crane operator followed that direction, and then the appellant was injured. For these reasons, as between the special employer Timber Peaks and the general employer Marco Crane, there was no dispute at the trial court that at the time of the injury-causing event, the details of the work were being supervised by Timber Peaks. That is why the Superior Court entered judgment.
Counsel, I understand the facts and circumstances of this case, but if the facts had been different, if the direction was, we want this to move from point A to point B, and then Timber Peaks did nothing else, would the outcome be different then?
Sure, Your Honor. Under a different set of facts, we might have a different outcome. The facts here were that all directions of Timber Peaks was followed by the crane operator. But if there was some fact that the crane operator was doing something else entirely of his own volition, apparently, that might be a different situation. But here, Your Honors, that's just not the case. Now, appellant urges this court to vacate the judgment below because the claims that legal error was made. The appellant urges this by asking this court to ignore binding Arizona Supreme Court precedent, which sets forth what the legal test is. And that is done because the appellant in the opening brief, as well as in the reply brief, conflated two separate legal doctrines, the lent employee doctrine and the borrowed servant doctrine. But what we're dealing with here is the borrowed servant doctrine. Appellant's arguments should be rejected for two reasons. The first, because the Superior Court properly applied the vicarious liability borrowed servant doctrine, as was stated by the Arizona Supreme Court in Terry versus Bowen Manufacturing. And second, because there is no dispute as to the material facts that Timber Peaks had the right to control the details of the work at the time of the injury-causing event. Now, the lent employee doctrine is what contains this three-element test that is recited repeatedly by the appellant in their opening reply brief. We're dealing with two different doctrines here that arise from the same set of facts. You have a general employer who leases an employee to the special employer. The way you know which test applies, Your Honors, whether it's the three-element test or the right to control, is you look at who was actually injured and is bringing the claim. So in every case that's cited by appellant, where this court or the Arizona Supreme Court uses the three-element test, it's because the lent employee themselves was injured. That's what happened in Ariza versus US West. That's what happened in Nation v. Weiner. That's what happened in Wiseman versus Dyntech Air. The lent employee themselves was injured. But in a borrowed servant vicarious liability case, the borrowed servant is alleged to have injured a third party. Somebody else has been injured and is asserting that the general employer is vicariously liable. So that's what happened going back to 1970, which is the Wise v. Williams case, Arizona Supreme Court case, the Ruelas versus Staff Builders case, and as well as most recently the Tarrant versus Bowen Manufacturing case. There is no question, Your Honors. The appropriate test is who had the right to control the details of the work being at the time of the injury-causing event. If the court has any questions as to which test applies, I'm happy to address those. But if not, I'll move on. So there are no disputed issues of fact here, Your Honor. Instead, what the appellant is urging this court is to adopt a new strict scrutiny sort of micromanagement test, which is that unless, as the appellant said, the operator is being told what buttons to push, what levers to pull, that the right of control could not be met. And that's just not what Arizona courts have required, Your Honor. And for that reason, that fails. The appellant also draws upon presumptions in factually distinct cases saying, well, that maybe they were cooperating with Timber Peaks. Again, those are factually distinct cases, and I'm going to address those in a moment. Now, first, Judge Cruz had referenced the situation of a nurse and a nurse giving a vaccine. What that is very comparable to is the Ruelas versus Staff Builders case, Your Honor. In that case, you had a general employer who leased a nurse to a hospital who was the special employer. The special employer directed the nurses to give an enema to a patient. That patient then brought suit claiming that they had been abused in that process. In that case, the borrowed servant doctrine was applied. Summary judgment was granted in favor of the general employer. And let's look at what the courts found the level of control to be. What you can see at paragraph 3 is that the only direction that was given by the special employer was, go give that patient enema. It was not a requirement by this court that for the right to control to be met, that the nurses had to be walked through that procedure as to how to give the enema to the patient. No, all that was required was that to show the level of control was that direction, and an absence of evidence that the general employer was somehow directing the care of these patients. That was the business of the special employer. You can also look at the Lee versus M&H Builders case. Now, to be clear, the Lee versus M&H Builders case is a lent employee doctrine case. That's why the 3 elements are cited and applied in that case. But one of those elements is the right to control, and that's why it's analogous for this court to take a look at. And what you can see in paragraph 35 of that case is a description of the work that was performed. Mr. Lee was a lent employee to the special employer. He showed up to the job site. He was told by a supervisor of the special employer, go clean those refrigerators. In the process of cleaning the refrigerators, the appellant slipped on something, he fell and was injured. The right to control was found in that case by this court. There was no requirement that the special employer had to say, take a sponge and water, go soap down the refrigerators, use a counterclockwise motion. None of that highly scrutinized detail was necessary. So what appellant is urging is this court to adopt a new test, which is not found in Arizona case law. The appellant actually goes so far to claim in oral argument today that the borrowed servant doctrine could never be met with a crane operator because of the complexity of the work that he claims a crane does. Well, first of all, the appellant's argument is inconsistent. Appellant argues on the one hand that the operation of the crane is so specialized, so beyond the ability to be supervised, that it must have been the general employer supervising them. But at the same time, the appellant argues that the work being performed was so simple that no supervision was necessary. It's counterintuitive, Your Honors, and that argument, there's a reason that argument has not been adopted by any of the courts or in any cases which are cited by the appellant. Rather, what we have, the closest to the state, the closest case we have, Your Honors, is the Nepstead versus Lambert case, which is the Minnesota Supreme Court case 235 MINN1. And in that case, very similar facts. You had a crane and 2 crane operators who were leased to a builder who was building a building. The undisputed facts were that the crane operator followed the directions of the special employer supervisor at every step. It was a direction by the special employer supervisor that led to the injuries of the plaintiff in that case. And the court in that case said that effectively the crane operator was nothing more than a, quote, automatic eye doing whatever he was told. And for that reason, the right of control standard was met. For the same reasons here, the right of control standard should be met, Your Honors. And in fact, the case in front of you is even more clear because of the contractual language. In Nepstead, there was no contract, or at least the contract did not address the party's intent as to the right to control. And so the court had to look at more facts. But here, the contract is clear, what actually occurred as between the parties. And you don't see Timber Peaks arguing that, no, actually, the general employer was in charge. No, the special employer was in charge. There's no dispute as between Marco Crane and Timber Peaks that Timber Peaks was the one controlling the details of the work.
Counsel, you have 10 minutes left.
Thank you, Your Honor. There's also cited by the appellants in their papers the Inman case, Inman versus Crane Rentals case. And in footnote 7, it stated that there can be a presumption that when you have equipment and an operator leased, that there may be some intent on behalf of the general employer to retain the right to control. Inman is a completely distinguishable case, Your Honors. The language that is used by this court in Inman case is very important. If you look at paragraph 26, quote, the court said, plaintiffs have set forth facts showing that defendants rented to DeRusha, that is the special employer, both machinery and an operator of that machinery. As the restatement demonstrates, reasonable people could conclude, based on these facts, that the general employer maintained some right of control over the crane's operation, and this is the critical language, Your Honors, that it was the understanding of the parties that it would do so. Inman is distinguishable, Your Honors, because there was no contract that stated which party intended to have the right to control. So therefore, the court had to, there was a question, what was the understanding of the parties as to who was going to be controlling the details of this work? That issue is not in our case. We know from the contract language, we know from the actual actions of Timber Peaks and the crane operator at all times, the details of the work were controlled by Timber Peaks. Now, the argument was also raised by—
Oh, we just lost counsel. Or did we?
I think he just turned his video off.
No, I'm back.
We're
I had
okay.
to scratch my ear. Sorry.
There was also an argument, Your Honors, that the hand signals that were provided by Timber Peaks was just mere cooperation. But the cases that are relied upon by appellant are, again, factually the same. The Standard Oil case, which was in front of the United States Supreme Court, was cited by appellant here at oral argument today. In that case, what you had was a stevedore, which is a party that loads boats, was providing hand signals to a winchman, which is just the person who operates the machinery. Sounds similar, right? But this is where things are different. The general employer, Standard Oil, owned the dock that the loading was taking place on. The general employer owned the materials that were being loaded onto this. And also, as the court noted, the general employer reserved to itself the right to actually control the lifting. So it was more as if, so they were cooperating together to get this job done. But that's different than the case before you. The undisputed record is that this was Timber Peaks' job site. Timber Peaks was the one that was in charge of building this building. Marco Crane was only leased its employee because that was Timber Peaks' request. Timber Peaks chose to build its building using a crane. That was its choice. These are not distinct activities, Your Honors, because Timber Peaks chose to use that crane. So these hand signals were not in cooperation. And if there's any doubt, as I noted at the beginning, the undisputed evidence is that the Timber Peaks foreman told the crane operator, "I'm the boss." These were not cooperative hand signals, Your Honors. They were authoritative. And that is what shows the right to control. Appellant argued in their oral argument that effectively what Marco Crane is arguing is that anytime some worker steps onto a job site because they're hired to make a delivery, they're automatically the special employer. And just to be clear, honest, that's not what we're saying at all. We're saying under these specific facts, where there is a contract where the general employer has ceded all right to control to the special employer, where the undisputed evidence is that every aspect of the work performed by the crane operator was at the direction of the special employer, that under these facts, the crane operator is the special employee for purposes of vicarious liability.
Counsel, would the outcome be more in doubt, in your opinion, without the contract language?
Under those facts, Your Honor, yes. I think there would be a question because in almost every case that's actually cited by the appellant over this issue of who had the right to control, it's because the contract didn't address that issue. And so the court was left with this issue of, okay, how do we interpret the various actions that took place on the day in question?
But counsel, even if there was a contract, that's but one factor. So if even with the contract, we have to look at what the actions of the parties actually were, not only what they contracted to do, because isn't that what happened I believe in Tarrant?
You're absolutely right, Judge Cruz. In the Tarrant v. Bowen case, the court said that the contract language is not solely determinative. You have to make sure that the boots on the ground match the contract language. And in this case, that's exactly what happened. There is no evidence that the crane operator did anything other than what he was told to by the Timber Peaks employees. You know, if there's any doubt as to which party should be vicariously liable, that question was addressed in the Tarrant versus Bowman manufacturing case, where the Arizona Supreme Court cited the restatement, section 7.03, with approval. The quote, practical allocation of liability. What the court said is that the party that was in the best position to prevent the harm should be the one who is vicariously liable. And in this case, that could only have been Timber Peaks. This was Timber Peaks' job site. Timber Peaks performed all of the signaling. Timber Peaks could have erected safety structures. There's no indication on the record that Marco Crane had anything to do with the management of that job site or the direction of the crane operator. If this court has any questions on any of the cases cited in the briefing, I'm happy to address those. If not, thank you, Your Honors.
Thank you, counsel. All right, Mr. Abney, I show 4 minutes, 55 seconds.
Okay, well, with a little luck, I won't use all of that. My colleague across the aisle started out by talking about what, when, and where, but he never used the word how. And the important question here is who is in charge of how that crane is actually operated. I also want to thank him for clarifying the facts a little bit. When I read the record, I was a bit confused as to the sequence of what happened during the 3 loads that this crane operator was supposed to make before he left the job site. And so we're at the first load, and he gets a direction lift, and things go badly right there. It seems an awful lot to say that he's converted into a special employee simply because of one direction to lift a load. That puts an awful lot of weight into something that is a fairly minor direction. When you get right down to it, I was in the Terran case, for instance, the employees had removed some access ramps, and instead of covering over a gap that had been created or installing a barrier, they simply put some tape across it. And the end result as to whether they were special employees or were the employees of their original employer was really a question of fact. And that's how Terran was decided. This is a question of fact. At a minimum, what we've got here is a question of fact. What exactly is the extent of the control? You've got this wonderful boilerplate contract that says we control everything. You've got supposedly a foreman there saying I'm in charge, and all that's great. But who was really in charge of controlling the details of the crane operation is a question of fact. I submit to you that the facts are so strong that you could decide, well, the crane operator controlled. But if you have any doubt whatsoever, then it really is a question of fact for the jury to resolve. I think I've made my main points in the first time around and in the briefing, and if that's so, I will cede my time to the court.
All right. Well, thank you to all the counsel for your arguments. We will take the matter under advisement, issue our decision in due course. And with that, the court stands in recess.
Thank you, Your Honor.
Thank you.